Clerk will report.
Mr. Chairman, 14 members responded to the quorum call.
A working quorum being established.
Mr. Chairman.
Chair recognizes the gentlelady from Texas, Sheila Jackson Lee.
Mr. Chairman, thank you so very much. I'd like to call up Amendment 814 and 8112 in block, Jackson Lee.
Clerk will report the amendments.
Amendment to H.R. 5503 offered by Ms. Jackson Lee of Texas. Add at the end the following. Section 9, multi-party litigation.
I ask unanimous consent that the amendment be considered as read.
Gentlelady is recognized in support of her amendments.
I thank the chairman very much. First of all, again, I'd like to express my appreciation to Chairman Conyers, who about 10 days ago met with me a number of victims and heard their plea and their stories. During our break, I had the privilege, and I call it privilege, to meet a number of other family members who have lost loved ones. And again, I say to them, my deepest sympathy, but most of all, I apologize to you. I have no conflictedness in apologizing to the offender. In listening to what has occurred over the past couple of weeks, what struck me again and again was an interview by a survivor that was reported over the last 24 hours. And that survivor said that he indicated to the supervisors that the BOP was leaking and that that leak was not being repaired. Days out. And he said over and over again, clearly there was no response until the tragedy of April 20th. This legislation is right because it deals with retroactivity. But I would like to talk very briefly about making sure every aspect of the concerns of the people of the Gulf are considered. I have an amendment on multi-party litigation that amends the Jones Act that I think further clarifies the ability of the states to move themselves out of multi-party jurisdiction to be able to defend their cases on behalf of the citizens of individual states, because the multi-party litigation causes them to pile up in one court. And I would like to clarify or make sure that the victims and the citizens of the individual harmed states can move as quickly through the courts as possible. And my amendment would provide for that. My other amendment deals with a question of an industry that is being impacted, and that is the tourist cruise industry that in fact protects and recognizes their responsibility to the traveling public and as well to their employees. But in this legislation, there is the possibility of confusing provisions given to oil workers to our cruise workers as well. This has nothing to do with criminal activities. It has nothing to do with potential impact on passengers where, in fact, those passengers would be harmed. This directly relates to employees. And my legislation would say that if the foreign employees or amendment had the appropriate remedy in their foreign country, meaning that they were not barred from the courts, then that would be the particular remedy that they would secure and would not need to secure any other remedy. Mr. Chairman, I know that you understand the importance of legislation that should be balanced, and therefore I believe that we would have the opportunity to sit down and discuss these particular amendments and effectively make sure that they amend this legislation appropriately. Let me add one other point. I have Amendment 819 that I've not yet submitted, but I believe this is important. BP has made the point that they will pay every legitimate claim. I obviously am concerned about that because having visited with shrimpers and others and small energy companies, I am concerned that the negative impact of what has occurred with BP labels and taints the entire industry, the same industry that victims have said they want to see continue safely in order to be able to continue not having the economic impact. So I will also be introducing and working with this committee and others on tiering the liability issue under LOL and under the Oil Pollution Act, so that small, very small mom and pop energy companies, and for those of you that are not from the Gulf, those kind of companies do exist. Mom and pop energy companies who comply with all of the safety rules are not negatively impacted by this legislation. With that in mind, let me indicate to my colleagues, I look forward to working with the chairman in this committee. I supported the manager's amendment and go on record for supporting it, and go on record as asking, having the amendment represent the support of Congressman Conyers and Congresswoman Sheila Jackson Lee. But I do believe that there are ways that we can speed through the litigation of these particular plaintiffs, and as well make the state stronger and provide support for our cruise industry that has provided such a base of the economy in the Gulf region. Mr. Chairman, I am going to ask now unanimous consent, thanking you for the courtesies and looking forward, if I could, to working with you. And let me just yield for a moment, Mr. Chairman. I would appreciate if we could work together on some of the points that I've just made.
The gentlelady would yield.
I'm happy to yield, Mr. Chairman.
Delighted to inquire further into the two bills and the underlying issues that are involved.
I thank the chairman very much. This is a good first step, and I thank you for your work and enjoyed working with you on the manager's amendment. And with that, I would ask unanimous consent to withdraw my amendments. Looking forward to working with you on this issue. I ask unanimous consent to withdraw the amendments.
Without objection.
Mr. Chairman.
Mr.
Chairman.
Oh,
Chairman.
Dan Lundgren. Bob Goodlatte.
Mr. Chairman, I have an amendment at the desk. Goodlatte Amendment number 2.
I'd like to have the clerk report the amendment.
Goodlatte Amendment Number 2 to H.R. 5503, on page 4, line 9, after citizens, add in a class action arising out of an oil spill. On page 4, line 13, after citizens, add in a class action arising out of an oil spill.
Gentleman is recognized in support of his amendment.
Thank you, Mr. Chairman. Mr. Chairman, in recognition of the outcome of the last amendment, which was along a party line vote, I have a solution that addresses your concern and could bring us all together. And that would be to simply make it clear that the provisions of H.R. 5503 that alter the Class Action Fairness Act only apply with respect to actions arising out of an oil spill. The proponents of H.R. 5503 claim that the underlying provision is necessary to allow lawsuits to move forward to address the disaster in the Gulf. This amendment incorporates that and would allow lawsuits seeking redress of oil spills to move forward despite the Class Action Fairness Act rules, while preserving those rules for all other cases. This is a narrowly tailored amendment that protects the current Class Action Fairness Act while addressing the specific issue at hand, Gulf disasters caused by oil spills. And, Mr. Chairman, I would urge you to accept this amendment or something like it, simply because I think broadening out the debate and making changes that affect many other class action lawsuits around the country is going to bring in parties to attempt to challenge what we're trying to accomplish here with regard to the ability of those in the Gulf who are aggrieved to be able to bring actions as they see fit. So I'd urge my colleagues to support this amendment.
Well, this is one amendment that I must say that we did not anticipate. I've got to be sure that I would live more happily ever after with this amendment than had you not if you had succeeded on your first try. Could I inquire about the line of cases that I quoted that in which the courts have said parents, patriae, and class actions all get interpreted the same way, and that they are accepted, that removals from state jurisdictions to federal are perfectly permissible?
Well, if the chairman would yield, under the two decisions that you cited, each one is unique in the sense that in the first one involving the canal, that was a case in which the Attorney General joined a private lawsuit. It was not the Attorney General bringing a separate lawsuit on his own that would enable the matter to be kept in state court, because of the nature of that lawsuit involved plaintiffs and defendants from more jurisdictions that, under federal law, for the purpose that our federal courts and diversity jurisdiction exists, could be removed to a federal court. With regard to the other case, that's a situation in which the Attorney General brought an action on behalf of a very narrow and limited class of people, not in the sense of an ordinary parents patriae case brought on behalf of the citizens of a state. And again, the court adopted a narrow interpretation of the law that indicated that that did not fit the definition of a traditional parents patriae case, and allowed it to be removed to federal court. Again, once the court makes that decision, that does not automatically remove a case to federal court. It simply then says that the other criteria for removing a case to federal court must be examined, and the court did that and found that it met those criteria.
Mr. Chairman.
Who seeks recognition? Yes, I yield to gentlelady from Texas.
I think the arguments that we made on the underlying amendment of Mr. Goodlap are appropriate for opposition to this amendment. Frankly, the bill that you have put forward, and the committee is now reviewing, is not an isolated legislative initiative on an oil spill. It frankly is, I believe, correcting the failures of the class action as relates to catastrophic events such as what has just occurred. And I would argue that if we put in the language of oil spills, there may be another catastrophic event that requires states to want the same kind of relief. If that is the case, we then now have sent forward a bill that only refers to oil spills, and I would be concerned about that. I think we are sound on the way the class action has been amended, both in the manager's amendment, which talks about mass action, and it helps to expedite in these instances. And so I would oppose the gentleman's amendment because it is narrow and limiting, and it does not go to the intent of this legislation, I hope, which is to broadly correct what might be a failure as relates to class action, and I hope, as I discuss with you further, multi-district litigation. I yield back. I oppose the amendment.
Mr. Chairman, if you might yield just briefly again, I have one other point that may be of interest to you.
All right.
In the Class Action Fairness Act, there is already discretion for the court. It provides in Section 3, a district court may, in the interest of justice and looking at the totality of the circumstances, decline to exercise jurisdiction whether the claims asserted will be governed by laws of the state in which the action was originally filed or by the laws of other states. So it seems to me that that, coupled with this amendment that I'm offering here, would address your concerns.
Well, Bob, here's the problem. These carve-outs could leave me with sleepless nights for the following reasons. What if it was another natural disaster, but it was not, in fact, an oil spill? And the same with those that want to carve out an exception for cruise ships. You know, we're now moving into the carve-out phase. And oil oil spills are not the only environmental disaster that can create problems. So I don't know why, just because the event of April 20th was an oil spill, why do we just cover that alone? Why? What about if it's some other environmental problem?
No, Mr. Chairman, the fact of the matter is all of this legislation is taking place because of the emergency circumstances that have been brought to your attention. If there needs to be broader changes to the Class Action Fairness Act, then let's have a hearing on the Class Action Fairness Act. But to make a change that is more broadly applied in its scope than what we know about is, quite frankly, to not give a fair hearing to existing law that many people think has worked very well. Obviously, a couple of people on your side have testified that, or spoken today and saying that they don't like aspects of it. Let's have a hearing on it, but let's not change it in this expedited process that we're undertaking for enduring effects that we don't know what the unintended consequences are at this point. Let's just apply it to the matter that's facing us right in front of us, the oil spill that we're concerned we need to make sure people can bring appropriate actions.
Well, let's agree that our staff should work on this and that we may be heading toward a particular hearing under the on the Class Action Fairness Act. But I approach this on a wider scope, and I think you do it, and most of our committee does too. This isn't just about oil spills. We've got some environmental problems that may come up in other contexts. So while our staff is studying this, let's move this legislation through without this carve-out. I think we'd be better. I'm still open for discussion.
Mr. Chairman, if you're suggesting that you and your staff would be willing to work with Congressman Boucher and I on the language that's in this bill with regard to the Class Action Fairness Act and try to arrive at something that would be more agreeable, we would certainly be willing to do that with you and withdraw this amendment.
Thank you. And I commit to that agreement.
Well, thank you, Mr. Chairman. We'll do that.
Without objection, the amendment is withdrawn. And we turn now to the former Attorney General of California, Dan Lundgren.
Thank you very much, Mr. Chairman. I have an amendment at the desk.
Clerk will report it.
Amendment to H.R. 5503, offered by Mr. Daniel E. Lundgren of California. Add at the end the following: Section Waiver of Restriction on Operation of Foreign
Ask unanimous
Vessels.
consent the amendment be considered as read.
Without objection, the gentleman's recognized.
Mr. Chairman, the Deepwater Horizon catastrophe is obviously tragic in terms of the loss of human life, but also we have the concern about the untold damage to the environment of the Gulf region. The circumstances are obvious to anybody who watches on television and sees the damage done. And it appears to me that virtually everyone agrees that we've got to do everything we can to facilitate the cleanup operations in the states affected. For this reason, I'm offering an amendment to the Merchant Marine Act of 1920, otherwise known as the Jones Act, stating that the sections should be suspended.
Reserve a point of order.
Who reserves the point of order? Gentlelady from Wisconsin's point of order is reserved.
And Mr. Chairman, right now, under the Jones Act, foreign flag ships are unable to participate in emergency oil spill cleanup operations if, in fact, the foreign flag vessels travel between two U.S. ports. And, of course, that's what they'd have to do if they were actually to assist in the emergency oil spill cleanup. As someone who grew up in and around major U.S. ports in Long Beach and Los Angeles, I have a great respect and admiration for those who work on U.S. flag vessels and understand the important national interest in ensuring the strength of our American fleet. However, it seems strange that during a national crisis where an oil spill has taken place, that somehow we would refuse the offer of assistance by foreign countries because their vessels are in fact foreign flagged. And there is every bit of evidence that in this particular case that has caused a delay in the response. That is, that there is a limit to the capacity of vessels that we have, skimmers and others, to respond to a disaster such as this. Other countries, particularly Holland or the Netherlands, have expertise in this area, have capacity that was not utilized. And because of the impact of the Jones Act, we're not allowed to participate in this recovery. If an adequate number of vessels documented under the laws of the U.S. cannot be found, and if the foreign country has accorded similar privileges to the U.S. vessels under similar circumstances, we should, I hope, on a temporary basis, draw upon the assistance of U.S. flag vessels for help. The environmental areas damaged really don't discriminate against whether or not it's a foreign flagged skiff that is attempting to try and protect it or a U.S. flagged vessel that is doing that. So I would hope that we would respond to this tragic circumstance by recognizing one of the shortcomings of the Jones Act. We need to do everything we can to have all of the equipment that is available worldwide, because this is a global, not only global economy, but this is a global enterprise. These rigs find themselves, if they're not offshore the United States, they'll be transferred to other places, Australia, off the coast of Brazil, Africa, etc. All of the equipment that is necessary to protect against the impact of some of these disasters is not available here in the United States. So I would hope this is not a radical notion. My amendment incorporates the language of existing federal statutory authority under 46 U.S.C. Section 55-113. In the bill before us today, we are making changes in the Jones Act, with all due respect, Mr. Chairman, without a lot of hearings, but we're doing it in reaction to the emergency exigent circumstances. I would hope that we would do that here as well. We should make it crystal clear that our effort to expand the parameters of the Jones Act include first and foremost an unequivocal commitment to do everything within our power to ensure that all the tools available worldwide can be used to protect the United States. And so, Mr. Chairman, that's why I offer this amendment. I hope it's not controversial. And because the bill before us deals with securing the protections of the injured from limitations on Liability Act, there is a limitation right now for protecting the injured critical habitat in our coast, and that is a law that prohibits those who have requested permission to assist us, a law that prohibits them or prohibits us from accepting that help. So, Mr. Chairman, I offer this in a spirit of bipartisanism and with the hope that we could get support on this. And with that, I yield back the balance of my time.
Does the gentlelady from Wisconsin insist upon her reservation?
Yes, I would like to press the point of order that the amendment before us is not germane to the underlying bill. The underlying bill relates to civil actions for tort liability, and this relates to rules relating to flagging and manning ships. While there was reference to the Jones Act, Jones Act is a sweeping piece of legislation. Our underlying bill only addresses a small part of the Jones Act, and so I don't think that is adequate leverage to make this amendment germane.
Dan Lundgren, do you have a response to this point of order?
Mr. Chairman, the title of this bill is Securing Protections for the Injured from Limitations on Liability Act. I seek to secure protections for the injured infrastructure, which both affects the environment and the American citizens on or around the coast affected by this tragedy. There are limitations on those who can assist based on whether or not their flag is foreign or domestic. And it seems to me that's a limitation on our ability to protect. And I understand that this bill is not precisely on point here, but under the emergency circumstances, I'd hope that no one would offer a point of order if, in fact, what we're trying to do is to respond immediately to an emergency and to do something to help the people in Louisiana. If you've seen the governor of Louisiana, if you've seen the other people down there desperately asking for assistance, and one of the responses of the federal government is you can't have all the assistance that is there because we have limitations under the Jones Act, it seemed to me to be a very natural and reasonable thing for us to try and do it here without hearings. But I understand that sometimes the process is appropriate. And Mr. Chairman, before yielding back my time, I would just say to you, Mr. Chairman, I very carefully listened to what you had to say about carve-outs and your objections to them, and so I hope you will support me on the floor tomorrow when we deal with the Disclose Act and the large carve-outs dealing with auctioning off parts of the First Amendment tomorrow. So I'd be happy to yield on my response on the objection by way of point of order.
I thank the gentleman for yielding. Mr. Chairman, I just want to say I hope the point of order is not insisted upon either. The gentleman from California just said this is an emergency type of situation. I also want to point out that 5 years ago, in the aftermath of Hurricane Katrina, President Bush waived the Jones Act, easing the way for foreign vessels to move into U.S. waters. However, unlike President Bush, President Obama so far has declined to suspend the act, even temporarily. Thus, foreign countries are being turned away when making legitimate offers of help. As oil washes up on our shores, there's little reason not to temporarily waive the act and take advantage of offers of assistance from our foreign allies. So I support the amendment and hope the majority will not insist upon their point of order, and I'll yield back.
Well, members, this objection is a question of germaneness. And so that goes to the scope of the bill before us. And that scope is federal law regarding civil actions related to tort liability. The amendment deals with rules for flagging and manning ships in the United States coastwise trade. Now, the amendment deals with a different subject matter and a different purpose. And what it would do, in our view, is that it would broaden the bill beyond its current scope so that it would be referred to another committee, namely the Transportation Committee. And so, perusing Rule 16, Clause 7, the chair rules the amendment to be not germane to the bill. And so I will not be able to entertain the amendment any further. Where is he? Gentleman from Florida, Mr. Deutsch.
Mr. Chairman, I have an amendment at the desk.
Clerk will report it.
Amendment to H.R. 5503, offered by Mr. Deutsch of Florida. Page 4, line 17, strike subsection B.
Mr. Chairman, I ask unanimous consent the amendment be
C.
considered as read.
Without objection, the gentleman is recognized in support of his amendment.
Thank you, Mr. Chairman. This amendment addresses Section 6B of the underlying bill. Section of the bill provides an exception to Section 6, which makes certain secrecy agreements regarding the discharge of contaminants into U.S. waters unenforceable. Under the exception, a directive for secrecy agreement that's contained in a court order is enforceable, and the exception also permits the issuing of secrecy agreements by a government agency that has the authority to enforce the agreement in court. This amendment would make two important changes to the exception. First, the amendment would require that a court granting the enforcement of a secrecy agreement that is needed for the public health and safety must state factual findings and conclusions of law relating to the enforcement of the agreement on the record. And second, the amendment would require that in the event a government agency is enforcing their secrecy agreement in a court, that the agency demonstrate by clear and convincing evidence that the agreement is needed to protect the public health or safety. It's crucial to emphasize that the underlying bill is only addressing secrecy agreements that restrict the dissemination of information regarding the cause of a discharge into the water of a contaminant, the nature and extent of the discharge, the damage caused or threatened by the discharge, or information regarding remediation. This amendment would encourage a court that orders a secrecy agreement restricting public access to this information to be well informed, possibly through a hearing, witness testimony, or submission of other evidence, before taking steps to restrict public access to information on contaminants that have been discharged into U.S. waters. It also places a reasonable burden on a government agency that seeks to keep information secret on the discharge of contaminants into our waters. If a government agency wants to keep information that affects the public health or safety secret and out of public dissemination, they should have to satisfy that burden of proof. Indeed, our laws should reaffirm that it's of the utmost importance that the public have access to information that impacts their health and safety. Secrecy agreements on information that impact the public health or safety are in opposition to our nation's tradition of having courts that are open to the public and a government that is open to the people. Keeping information secret from the public, especially if the information relates to public health or safety, should only be a last resort, and this amendment will ensure that that is the case. I yield back.
I thank the gentleman from Florida. I've gone over his amendment, and we find that it's very well crafted, and on our side, we're prepared to accept it. And I would yield to Lamar Smith.
Thank you, Mr. Chairman. Mr. Chairman, I don't know if this amendment is necessary or not, but I think it's a good one. To quote from the amendment, quote, "The court shall state the court's factual findings and conclusions of law relating to that enforcement on the record." Like I say, I'm not sure it's necessary, but I think in the interest of transparency in the judicial process, it's a good effort to make sure that that transparency occurs. And so I encourage my colleagues to support the amendment as well.
I thank the gentleman from Texas. The questions on the Deutsche Amendment, all in favor say aye. All opposed, the ayes have it, and the amendment is carried. A reporting quorum being present, the question is on reporting the bill as it amended favorably to the House. All in favor say aye. Aye. Yeah. This is reporting H.R. 5503. A reporting quorum being present. The question is on reporting the bill as amended favorably to the House. Those in favor say aye. Those opposed say no. Ayes. The ayes seem to have it.
Mr. Chairman, I would request a recorded vote.
Recorded vote is sought by the gentlelady from California, Zoe Lofgren. The clerk will call the roll.
Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Berman? Mr. Boucher? Mr. Nadler? Mr. Scott? Mr. Scott votes aye. Mr. Watt? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Wooters? Mr. Delahunt? Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Pierre-Louisi? Mr. Pierre-Louisi votes aye. Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Ms. Chu votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Baldwin? Ms. Baldwin votes aye. Mr. Gonzalez? Mr. Weiner? Mr. Schiff? Mr. Schiff votes aye. Ms. Sanchez? Ms. Sanchez votes aye. Mr. Maffei? Mr. Maffei votes aye. Mr. Polis? Mr. Polis votes aye. Mr. Smith? Mr. Smith votes no. Mr. Gutlatt? Mr. Gutlatt votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Coble votes no. Mr. Gallagly? Mr. Gallagly votes no. Mr. Lundgren? Mr. Issa? Mr. Forbes? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Rooney? Mr. Rooney votes aye. Mr. Harper? Mr. Franks? Mr. Franks votes no.
Mr. Boucher?
Mr. Boucher votes aye. Mr. Lundgren? Mr. Lundgren votes aye. Mr. Gomert? Mr. Gomert votes no.
Mr. Forbes?
Mr. Forbes votes no. Mr.
Steve King?
Mr. King votes no.
Mr. Jordan?
Mr. Jordan? Jordan votes no.
Clerk will report.
Mr. Chairman, 16 members voted aye. 11 members voted no.
And the bill is agreed to. And without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating amendments adopted, staff authorized to make technical and conforming changes. Members will have 2 days for additional views. Pursuant to notice, we now consider a motion to authorize the issuance of subpoenas to British Petroleum America for documents regarding its claims process relating to the Gulf oil spill. My colleagues, I'm moving to authorize the issuance of subpoenas to BP to assure that the committee has the opportunity to obtain on a timely basis the information we need to understand the operation of the claims process. Now, since our hearings on May 27th, we've repeatedly sought to obtain information which would make the claims process more transparent, and we've been unsuccessful. And so when British Petroleum solemnly comes before this and other committees in the House to pledge to pay every legitimate claim without regard to any limitation, it begs the question of not only what claims are being paid and when, but why, what claims are not being paid. And so in a non-combative spirit as possible, it seems to me it's in BP's interest to be able to establish these facts rather than simply release claims-paid information as they're doing currently. Only yesterday, we were engaged in discussions with them regarding obtaining the information, and we're not getting anywhere. It's my understanding that they're telling us that they do not track the information, and that in any event, it's up to Administrator Ken Feinberg. And so I hope that what we do here today will put them on notice that we're taking this process quite seriously. There's a way that we can go about this, and we're hoping that we don't have to use this subpoena. But the chair is asking for this support so that that if it comes to that, if it's necessary, and I'll do this in consultation with the distinguished gentleman from Texas, that we do it, and I urge support for the measure and recognize Lamar Smith.
Thank you, Mr. Chairman. I support the motion to authorize the issuance of subpoenas to BP for documents regarding its claims process. BP is responsible for the Gulf oil spill and should pay all legitimate claims. And while BP has given assurances that they will do so, it's important that Congress is able to exercise oversight over the claims process. I don't believe that any of the documents sought in this subpoena relate to confidential information from either BP or individual claimants. So, Mr. Chairman, I support the motion and yield back the balance of my time.
The vote is on the measure before us. We will take a vote. All in favor say aye. Aye. All opposed say no. The ayes have it, and the motion is agreed to. I will invite
Crush video next.
hmm?
The next one is Crush video.
I'd invite Bobby Scott to take the chair at this point for the Crush video proposal that is before us. And I also wanted to acknowledge the presence of the former Lieutenant Governor of Texas, Ben Barnes, has been present with us. We recognize him at this point.
Pursuant to notice, I call up the bill H.R. 5566, the Prohibiting Interstate Commerce in Crush Videos Act of 2010, for purposes of markup. The clerk will report the bill.
H.R. 5566, a bill to amend Title 18 United States Code to prohibit interstate commerce in animal crush videos and for other purposes.
Without objection, the bill is considered as read and is open for amendment at any point. I recognize myself for 5 minutes for the purpose of an opening statement. First, I'd like to discuss the background of the legislation. In the late 1990s, Congress was made aware of a growing market for videotapes and still photographs depicting typically small animals being slowly crushed to death. These depictions are commonly referred to as crush videos. Much of the material features women inflicting torture with their bare feet or while wearing high heels. Depictions often appeal to people with a very specific sexual fetish. Even in states where harming animals in such a way itself violated state laws prohibiting cruelty to animals, prosecutors had difficulty obtaining convictions. For example, the faces of the individuals inflicting the torture often were not shown on the videos, and the locations, times, and dates of the acts could not be ascertained from the depictions themselves. Defendants were therefore often able to successfully assert as a defense that the state could not prove its jurisdiction over the place where the act occurred, or that the actions took place within the statute of limitations. So because it was hard to find the perpetrators of the underlying acts of cruelty to animals, and it was so difficult to obtain convictions, Congress adopted and President signed into law a new law prohibiting the creation, sale, and possession of the depictions of such acts. The new law was codified as Section 48 of Title 18 U.S. Code. The motivation for passing the laws was to address the sale of crushed videos, but the statute also applied to more mainstream material, such as videos depicting hunting and fishing and other activity protected by the First Amendment. In April, the Supreme Court invalidated the statute in the case U.S. v. Stevens. The court also held that the law was overbroad and violated the Constitution's First Amendment, but did not rule out the possibility of Congress adopting a bill that would hold up under scrutiny. The Subcommittee on Crime held a hearing about the decision in May and heard from witnesses who stated that a narrower legislative approach would likely be constitutional and survive court challenges. The bill before us is much narrower than the original law. The most important difference is the bill would only prohibit the sale of crushed videos that are obscene. This would address the key flaw in the original statute because obscenity is outside of the protection of the First Amendment, whereas some of the activity covered by the present law was in fact protected by the First Amendment. As the court found, the types of conduct and the protection that are covered by this bill are narrower than the original law and clearly not protected by the First Amendment. Furthermore, there is no confusion as to whether hunting or fishing videos are prohibited under this bill. They're clearly not covered. I commend my colleague from California, Representative Gallagher, and my colleague from Michigan, Representative Peters, who have worked together to produce this bipartisan bill. I yield back the balance of my time and recognize for 5 minutes the gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. First of all, Mr. Chairman, I want to thank Mr. Gallagher for introducing this legislation. An earlier bill on the same subject, I believe, attracted over 300 co-sponsors, which may well be a record for this Congress. H.R. 5566, the Prevention of Interstate Commerce and Animal Crushed Videos Act, responds to the Supreme Court's recent decision in U.S. versus Stevens, which invalidated the federal animal cruelty statute codified in 18 U.S.C. 48. Originally enacted in 1999 with broad bipartisan support, this statute attempted to address depictions of animal cruelty, including so-called animal crushed videos. The law was successful in virtually eliminating the market for these disturbing videos, which depict small animals being slowly crushed to death by women using their bare feet or while wearing high heels. All 50 states and the District of Columbia have laws banning acts of animal cruelty, such as those portrayed in these videos. However, animal crush videos often do not reveal the identity of those involved, making it difficult for states to prosecute the perpetrators for the underlying animal cruelty. Federal legislation is necessary to address the interstate sale and distribution of these videos, which is often beyond the reach of many state laws. Federal penalties will serve as an additional deterrent to those who engage in this cruel behavior. In Stevens, though, the Supreme Court held that the animal cruelty statute was overbroad under the First Amendment. H.R. 5566 proposes a very narrow statute aimed specifically at criminalizing animal crush videos. The primary sponsor of this legislation, Mr. Gallagher, has gone to great lengths to fully and effectively respond to the court's analysis. The bill limits this new criminal offense to obscene material. The Supreme Court has recognized Congress's authority to regulate obscene material as a category of unprotected speech under the First Amendment. I thank the Chairman, Mr. Conyers, for his attention to this issue and for bringing this legislation before the committee today. H.R. 5566 is a thoughtful, deliberate response to the Stevens decision that proposes a criminal penalty that will withstand constitutional scrutiny. Mr. Chairman, I'll yield back.
Thank you, and without objection, other members' opening statements will be included in the record other than Mr. Gallagher, who is the chief sponsor of the bill. Gentleman from California is recognized.
Thank you very much, Mr. Mr. Chairman, I want to thank you and the ranking member for working with me to draft this bill to put a stop to crush videos. By now, I think most of us, if not all of us, are familiar with these disgusting videos, as Lamar and others have said, feature small and defenseless animals secured to the floor and being slowly tortured to death, often by women wearing spiked heels and other attire. We're also in near universal agreement that these videos must be stopped, as we were when my bill first was passed in the House in 1999 by a bipartisan vote of 372 to 42 and by unanimous consent in the Senate and subsequently signed into law by then President Clinton. This is not just an animal cruelty bill, Mr. Chairman, it's a law enforcement bill. I first became aware of this issue when the District Attorney of Ventura County, California, came to me and brought it to my attention in early 1999. He explained that although crushed videos were illegal under the state laws, the crime was difficult to prosecute because video producers moved their goods through interstate commerce to avoid prosecution. The FBI, the U.S. Department of Education, and the U.S. Department of Justice consider animal cruelty to be one of the early warning signs of future violence by youth. The Boston Strangler, the Unabomber, Jeffrey Dahmer, Ted Bundy, all tortured animals before they began to murder people. As you know, Mr. Chairman, as you mentioned, the Supreme Court ruled in April that the 1999 law was too broad. In response to their ruling, I have introduced, along with my friend from Michigan, Mr. Peters, the Prevention of Interstate Commerce to Animal Crushed Videos Act of 1910. Based on the testimony of constitutional experts at the May 26th Crime Subcommittee hearing, I worked with the members on both sides of the aisle to craft legislation that is narrowly focused to prohibit crushed videos, rather than the broader depiction of animal cruelty. Mr. Chairman, immediately after the 1999 bill became law, the crushed video industry disappeared. It has reemerged in light of the court's ruling. Quick passage of this bill will once again stop these revolting videos that depict the torture and killing of defenseless animals. I want to thank you, Mr. Chairman. I thank the ranking member, both of you, for your comments in this markup, and I would strongly urge the committee to move quickly to support and vote for H.R. 5566, and I yield back.
Thank you. We'll ask other members to place their opening statements in the record without objection, so ordered. Are there any amendments? There being no amendments, the reporting quorum, I believe, is present. The question is on the favorably reporting the bill to the House. Those in favor will say aye. Aye. All opposed say no. The ayes have it, but there may be a question about a quorum, so I'm going to call for a recorded vote. Clerk will call the roll.
Mr. Berman, Mr. Boucher, Mr. Nadler, Mr. Scott. Mr. Scott votes aye. Mr. Watt, Ms. Lofgren, Ms. Jackson-Lee, Ms. Waters, Mr. Delahunt, Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Pierre-Louisi. Mr. Pierre-Louisi votes aye. Mr. Quigley. Ms. Chu. Mr. Deutsch. Mr. Deutsch votes aye. Mr. Gutierrez. Ms. Baldwin. Ms. Baldwin votes aye. Mr. Gonzalez. Mr. Weiner. Mr. Schiff. Mr. Schiff votes aye. Ms. Sanchez. Ms. Sanchez votes aye. Mr. Maffei. Mr. Polis. Mr. Polis votes aye. Mr. Smith. Mr. Smith votes aye. Mr. Gutlatt. Mr. Gutlatt votes aye. Mr. Sensenbrenner. Mr. Coble. Mr. Coble votes aye. Mr. Gallagly. Mr. Gallagly votes aye. Mr. Lundgren. Mr. Issa. Mr. Lundgren votes aye. Mr. Isa, Mr. Forbes, Mr. King, Mr. Franks, Mr. Gomert, Mr. Jordan, Mr. Poe, Mr. Chaffetz, Mr. Rooney, Mr. Harper. Mr. Harper votes aye. Mr. King. Mr. King votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Chu. Ms. Chu votes aye. Mr. Rooney. Mr. Rooney votes aye. Mr. Conyers. Mr. Conyers votes aye. Mr. Boucher. Mr. Boucher votes aye. Mr. Forbes. Mr. Forbes votes aye. Mr. Jordan. Mr. Jordan votes yes.
Do any other members want to vote? Clerk will report. You said you need.
Mr. Chairman, 23 members voted aye.
Thank you. The bill is reported without objection. The staff is authorized to make technical and conforming changes, and members will have 2 days to submit additional views. Do you mind? No. So to notice, I call up House Resolution 1455, directing the Attorney General to submit to the House of Representatives copies of certain communications related to certain recommendations regarding administration appointments, and move that it be reported adversely to the House. Without objection, the resolution is considered as read and open for amendment in any point. And on behalf of the chairman, I'll make the opening statement. This resolution was introduced by our ranking member, the gentleman from Texas, Mr. Smith, and referred to our committee. Although we have significant legislative business before us on the House rules, we are required to report this resolution within 14 days of its introduction, or a privileged motion to discharge the committee could be filed on the House floor. So we must put aside important legislative matters before us and address this resolution. And for 3 reasons, I recommend that we report it adversely. First, although there is no credible evidence that the Department of Justice had any involvement in or knowledge of any alleged offers to Representative Sestak or Mr. Romanoff, the Department has already responded to multiple inquiries from Republican members on this issue in letters of May 21st, June 14th, and June 15th. Attorney General Holder has responded to questions on the subject before this committee on May 13th. The Department has made it clear that any allegation of criminal conduct by public officials will be reviewed carefully by career prosecutors and law enforcement agents who will take any appropriate action. In addition, the White House counsel released a memo on May 28th describing what happened concerning Representative Sestak, and White House email to Mr. Romanoff has also been publicly released. Second, high-ranking Bush administration lawyers and others on both sides of the aisle agree that there is nothing illegal about offering a potential candidate for office an administration-appointed political position, even if partially motivated to avoid a divisive primary. For example, Stephen Bradbury, former Bush Assistant Attorney General in charge of the Office of Legal Counsel, acknowledged that there would be no criminal prosecution based on the conduct at issue here. Former Bush White House Ethics Advisor Richard Painter said on May 28 that, in light of the information released by the White House, it is even more apparent that this is a non-issue, no scandal, time to move on. Former DOJ Public Integrity Prosecutor Peter Zeidelberg, who once pursued charges against a top Hillary Clinton fundraiser, commented that you'd be laughed out of the courtroom for trying to prosecute the alleged conduct concerning Representative Sestak. Third, particularly in light of all of this, there is no proper basis for the resolution's specific document requests. There has been no indication that there was any guidance or recommendation from the department to the White House in this matter as in the first request. And if there's any new open investigation or review by DOJ or the FBI as to the alleged improper conduct, the FBI has explained that it would contradict long-standing policy and jeopardize an investigation to either confirm or deny its existence. Providing all documents related to such an inquiry as demanded in the second request would be even worse. The Department has also explained the long history of career officials handling such matters professionally and independently without need for special counsel. Former Bush Attorney General Michael McCoskey, who did appoint a special prosecutor in the U.S. Attorney matter, has agreed that there is no basis for one here. Indeed, the Department of Justice Inspector General found the U.S. Attorney matter involved improper conduct concerning and by Department of Justice and improper political pressure on federal prosecutors. At its core, that investigation was about ensuring the proper functioning of the criminal justice system, none of which is involved here. Those reasons, I recommend that we report the resolution adversely to the House and return as expeditiously as we can to other important business before the committee. Now recognize the ranking member of the committee, the gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. Today's resolution will help the President further his goal of increasing government's transparency and accountability. When President Obama was elected, he made grand promises of change in Washington. He claimed he would impose strong ethics standards on White House staff and promised to run the most open and transparent administration in American history. Unfortunately, the Obama administration has broken both of these promises. Rather than openness and transparency, the administration has engaged in regrettable backroom political deals. It has been 4 months since Congressman Joe Sestak disclosed that the Obama administration discussed with him a federal appointment in exchange for his dropping out of the Democratic primary for Senate in Pennsylvania. And it has been several weeks since Colorado House Speaker Andrew Romanoff disclosed he received a similar offer. It appears that administration officials may have engaged in an unethical and possibly illegal practice of manipulating Senate Democratic primary elections by offering candidates jobs in this administration. In the White House counsel's report released earlier this month, the administration admitted to making the offer to Sestak in an attempt to prevent a divisive primary that might have ended with a lost Democratic seat in the Congress. The President's political affiliation as a Democrat does not give administration officials carte blanche to do whatever they want simply because it benefits the Democratic Party. The most basic rule of American government is that no one, not even the administration, is above the law. Free, fair, and democratic elections are the cornerstone of our political system. Federal law protects fair elections by prohibiting government officials from using their positions of power to unduly influence election outcomes. It is a crime to offer someone a federal appointment as a reward for withdrawing from a primary election race. The Attorney General has a responsibility to ensure that all political officials, including administration officials, follow this law. The American people are not buying the administration's defense of everyone does it, or that's just how Washington works. Regardless of anyone else's behavior, President Obama made changing Washington the cornerstone of his campaign. Nobody asked him to promise open and transparent government, but when he did, Americans took his promises seriously. The resolution of inquiry we consider today directs Attorney General Holder to do what President Obama has failed to do for 4 months: transmit to Congress documents relating to the White House's potential illegal and unethical offers to Congressman Sestak and Speaker Romanoff. I am disappointed that this resolution of inquiry is even necessary, but the administration has ignored all efforts to conduct meaningful oversight. On June 8th, Mr. Sensenbrenner and I sent Attorney General Holder a letter asking for the documents we are now seeking by this resolution. And on Monday, Oversight and Government Reform Ranking Member Darrell Issa and I sent a letter to the White House highlighting a curious pattern of federal earmarks directed to congressional districts around the same time the representative decided not to run in the statewide Democratic Senate primary. If the administration has nothing to hide, why not provide Congress with the requested documents and restore integrity to our election process? It's time for the White House to make good on its promise of transparency and come clean about what other elections administration officials may have sought to influence. Mr. Chairman, I encourage my colleagues to support this resolution inquiry. Before I yield back, I'd like unanimous consent to put into the record the opening statement of our colleague Jim Sensenbrenner.
Without objection, so ordered. And without objection, other member statements will be included in the record. Are there any amendments? If there are no amendments, the question before us is the motion that the resolution be referred to the House adversely.
Mr. Chairman.
Gentleman from Virginia.
Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'm pleased to support this resolution of inquiry. Since the news of the Sestak and Romanoff scandals broke earlier this year, liberal commentators and media outlets have raised the argument that these sorts of offers happen all the time and that this is just, quote, business as usual, end quote. What they fail to admit is that business as usual is entirely incompatible with the change that this administration promised to bring to American politics. Change we can believe in, quote unquote, is a slogan that Americans became familiar with in 2008 and 2009 as this administration ran for office and began governing. Americans probably thought it referred to a promise to bring a new political culture to Washington. Obviously, they were mistaken. The reality is that this is not business as usual. Administrations in the past have relied on the wisdom of the American people to elect their leaders, not on powerful political interference in state primary races. But this administration is different. It passed a health care bill that reorganized 1/6 of the American economy and bailed out rich Wall Street banks. It should be no surprise, therefore, that the administration had to resort to highly unusual tactics to scratch the backs of those who scratched theirs. Supporters of the administration's actions with respect to the Sestak and Romanoff scandals must now make a choice. Do they continue to subscribe to the tired notion that this administration has brought change to Washington, or would they like to now admit that the administration is yet another reiteration of, quote, business as usual in Washington, D.C.? Mr. Chairman, the types of actions that are alleged regarding White House employees with regard to Democratic Senate primaries around the country is not business as usual. This committee should not acknowledge that it's business as usual and should go ahead and support this resolution of inquiry. The resolution of inquiry will deliver transparency about the Sestak and Romanoff scandals. This transparency is long overdue. I support the resolution and ask why anyone would not support providing for that kind of transparency when it comes to very serious allegations about wrongdoing in the White House. I yield back.
The gentleman's time has expired. Are there other amendments?
Mr. Chairman,
The gentleman from California is recognized.
I move to
for
strike the
amendment.
last word.
Gentleman's recognized.
Mr. Chairman, on May 28th, committee Republicans sent a letter requesting the FBI investigate the allegations regarding White House officials offering Rep. Joe Sestak a job. On June 8th, Ranking Member Smith and Sensenbrenner sent a letter to the Department of Justice requesting specific information to ensure Congress and the American public understand the DOJ's involvement in the Sestak and Romanoff matters. The responses from both the FBI and the DOJ, which did not address any of the serious issues raised in the letters, was disappointing at the very least. Although we can disagree about policy, we should all be able to agree that the Congress has not only the role, but a responsibility to oversee the FBI and DOJ. I would ask my colleagues to support this resolution to preserve congressional oversight of the administration. Thank you, Mr. Chairman. I yield back.
Are there other amendments?
Mr. Speaker,
Gentleman from Iowa, do you have an amendment?
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I support the pending resolution of inquiry, which is directed at the most politicized Department of Justice in recent history. The Department of Justice and this administration have a history of operating on a partisan basis, which is why it's essential that this committee conduct meaningful, thorough, and effective oversight of the Department of Justice to prevent its becoming just a political arm of the Obama administration. This resolution of inquiry attempts to break the culture of secrecy at DOJ that we have become all too familiar with under the Obama administration. We have the Attorney General Holder criticizing Arizona's immigration law before he's even read the law, and we heard that before us in this very room, Mr. Chairman. And we have also the Civil Rights Division saying that the people of Kinston, North Carolina, can't have nonpartisan elections on one of the clearest examples of this Department of Justice's politicization. It involves a mishandling of the new Black Panther case. In May of 2009, the Department of Justice made a sudden and still unexplained decision to abandon the case against the new Black Panther Party. That was the most open and shut case of voter intimidation in the history of America. It was on videotape. That's more open and shut than something that happened back post-Civil War. This case arose out of videos that show two members of the new Black Panther Party with billy clubs, smacking them in their hands, clearly intimidating voters entering and exiting the polling location in Philadelphia on Election Day, and calling people crackers. None of the three original defendants in the case even bothered to show up to court. Thus, the court directed Department of Justice to file the necessary paperwork to proceed with a default judgment, which very likely would have resulted in an important victory for the Department of Justice's efforts to prevent voter intimidation. Rather than moving forward with a default judgment, the Department of Justice reversed course and inexplicably dropped its case against all but one of the defendants. And as for the remaining defendant, we know that the Department of Justice did not seek or obtain the maximum penalty associated with voter intimidation, despite the testimony under oath by Assistant Attorney General Thomas Perez before the Subcommittee on the Constitution. She stated that the maximum was sought and obtained, but the facts in the case demonstrate that only a narrow injunction was obtained against the defendant. After 6 months of trying to get answers from the Department of Justice about this case, Mr. Wolf, ranking member of the Department of Justice's Appropriations Subcommittee, introduced a resolution of inquiry that was referred to this committee. Republicans voted in favor of that resolution, but we were outvoted, and the truth about the new Black Panther Party case to this day remains an administration secret. I fear that the resolution we are considering today will meet the same fate as the new Black Panther Party resolution, the one I just mentioned. Americans will be left in the dark yet again, and the administration and Department of Justice will get away with another tag team effort to advance a highly political agenda. I strongly encourage my colleagues to vote yes on this resolution of inquiry and break the cycle of secret political decisions at the Department of Justice. The American people deserve the truth about the Sestak scandal, and they deserve to know how the Department of Justice may have advised the administration in dealing with the consequences. And Mr. Chairman, in the Kinston, North Carolina case, for example, the people of Kinston, North Carolina voted by 63.8 to 36.2 that they wanted nonpartisan elections. The Department of Justice made a political decision. Some would say a race-based decision, and I would agree with that. The same person that canceled the new Black Panthers investigation also is the one that canceled the will of the people in Kinston, North Carolina, and that is Loretta King. She said, and this is Kinston, North Carolina, removing the partisan queue in municipal elections will eliminate the single factor that allows black candidates to be elected to office. Voters base their choice more on race than political affiliation. I mean, this is it's an appalling decision on the part of Justice, part of the Department of Justice, not to mention that there's not one nickel or one man-hour invested in the investigation of the criminal enterprise known as Acorn, and yet we have the Department of Justice investigating Arizona, not having read the bill. Yes, we need approval on this resolution that's been offered by Mr. Smith. I support it. I ask unanimous consent to introduce into the record the letter from the Department of Justice that addresses the Kinston, North Carolina case, and I'd ask unanimous consent.
Is there objection? No objection, so ordered.
And then, Mr. Chairman, I appreciate your indulgence, and I would yield back the balance of my time.
Gentleman's time has expired. Are there other amendments?
Mr. Chairman.
Gentleman from Arizona.
Move to strike the last word.
Gentleman from Arizona is recognized for 5 minutes.
Well, thank you, Mr. Chairman. Mr. Chairman, I support the resolution of inquiry that we're considering today because it's an important effort to conduct meaningful oversight of the Department of Justice. And one of our primary roles as members of this committee is to ensure that the DOJ properly discharges its duties as the nation's law enforcement agency and that it not engage in political affairs at the direction of this administration. This committee has considered numerous resolutions of inquiry this Congress seeking documents from the DOJ. Unfortunately, those resolutions have repeatedly been reported unfavorably out of this committee. For example, Mr. Chairman, you'll recall that the committee Republicans introduced a resolution of inquiry in November of last year, trying to understand why this administration still has not developed a coherent policy for detaining, trying, and transferring terrorists at Guantanamo Bay. It is utterly irresponsible for the Justice Department to continue to cobble together an ad hoc approach to the nation's war on terrorism. That resolution was also voted down by this committee. As a result, this committee is left without credible evidence that DOJ has an effective anti-terrorism policy. And when the Obama administration's policy for dealing with terrorists is simply, quote, trust us, Americans cannot help but feel less safe. Similarly, our resolution of inquiry to obtain documents from the DOJ regarding its policy for providing Miranda warnings to our enemies captured on the battlefield was also reported unfavorably. And still, months after DOJ, under the Obama administration, announced that it would reconsider where to hold the trial of 9/11 mastermind Khalid Sheikh Mohammed, still DOJ has left Americans in the dark about where this trial will finally be held. In fact, Mr. Chairman, the Attorney General has even refused to rule out New York City. When might we expect this political hot-button issue to be finally made public? Political reports that advocates on both sides of the issue expect that the administration will hold off revealing its true intentions until after the November elections. Even Senator Durbin has conceded the expediency of delay. Quote, we have to resolve that Guantanamo issue at another time. Asked that if he meant a non-election year, Durbin replied, quote, well, perhaps it'll be easier. That's a pretty cynical view and very accurate, close quote. Mr. Chairman, if the administration is taking the same view, then the administration's lack of transparency is nothing less than playing politics with national security. We can all agree that the administration's first job is to protect the United States from threats, rather than shielding itself from the accountability of the voters. Ironically, as you can see on the monitors, had to wait for a moment to make sure you could see on the monitors, the homepage of the DOJ website proudly displays an initiative called, quote, Open Government at the Department of Justice. And when you click on that banner, Mr. Chairman, you'll learn that this initiative was undertaken pursuant to President Obama's Memorandum on Transparency and Open Government. But the facts show that the DOJ, under this administration, is anything but transparent. And I strongly encourage my colleagues to vote yes on this resolution of inquiry and break the cycle of secret political decisions at the Department of Justice. The American people deserve the truth about the Sestak scandal, and they deserve to know whether the DOJ, this agency responsible for enforcing the laws of this nation, and for investigating these kinds of things, played a role in covering up the SESTAC scandal. And with that, Mr. Chairman, I would yield back the balance of my time.
Gentleman's time has expired. Are there other amendments?
Mr. Chairman.
Gentleman from Florida, for which purpose do you seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, during the 2008 presidential election campaign, President Obama made transparency and open government priorities for his administration. In fact, the day after his inauguration, he issued a memorandum directing the heads of government agencies to make government more transparent and user-friendly. It is strange, therefore, that the American people had to learn of the secret offers to Congressman Joe Sestak and Colorado House Speaker Andrew Romanoff from them, and not from this most transparent administration. And here we are 4 months after Congressman Sestak disclosed the offer to the public, considering this resolution of inquiry. This resolution is necessary only because the administration has failed to live up to its promise of open government for 4 months. If this administration were serious about transparency, it would have already produced the documents to Congress relating to discussions of quid pro quo offers to Congressman Joe Sestak and Colorado House Speaker Andrew Romanoff. Instead, Congress is left having to ask for information from the Department of Justice. Let me further explain what transparency means to this administration. On May 28th, the administration issued a short 2-page memorandum after months of political pressure to provide details about the Sestak issue. Congressional leaders and the media asked for more details, but they were not provided. Because the memo raised more questions than it answered, on June 4th, the ranking member asked that the full Judiciary Committee hold a hearing to investigate these deals. That request was declined. Then on June 8th, the ranking member, Mr. Sensenbrenner, sent Attorney General Holder a letter informally asking for the documents we're now seeking by this resolution. Once again, the administration blocked Congress's oversight function and the constitutional system of checks and balances. Finally, last Sunday, the administration announced on a Sunday morning political television show that it would disclose no additional information on this matter. As a last resort, the American people have turned to this committee to give life to the transparency that this administration promised us. Therefore, I support this resolution. I yield back the balance of my time.
Gentleman's time has expired. Are there other amendments? For which purpose, gentleman from California?
Mr. Chairman, I move to strike the last word.
Recognized for 5 minutes.
I join with the ranking member in believing that time has come to get answers from the administration on a number of troubling matters. Congressman Sestak has done nothing but tell us something that should never have happened. The administration, after 10 weeks of intense scrutiny and request by the press, issued a 1.25-page statement. It simply said, there's nothing illegal or unethical. Mr. Chairman, the American people know that this business as usual, which is the defense, is unethical and wrong. Whether it is illegal or not is up to a legitimate inquiry into the facts. But the facts are not forthcoming. Not in the case of Sestak, not in the case of Romanoff, not in the case of many other troubling events that we continue seeing going on in this administration's use of federal funds, potentially to clear fields to save tens of millions of dollars of political money. Mr. Chairman, since the days of Andrew Jackson, Congress has passed one after another strong laws to prevent simply campaigning based on payoffs if you're elected. We have additionally, under the Hatch Act, prohibited or put up the wall, if you will, of separation between government officials who are in fact political appointees and politics. The last administration was researched extensively for something as simple as firing their own appointees in order to replace them with other appointees. The chairman himself was very active in asking about the U.S. attorney firings and whether or not that was politically motivated, when, of course, no laws were broken. It is completely within the administration's right to hire and replace people that they appoint. And certainly today, this committee has a right to say Why is Rahm Emanuel still there when he used a yes, exactly. When he deceived and disguised his actions by using former President Clinton to offer something in order to clear the field, clearly showing that whatever he was offering and why he was offering it was something he did not want to have publicly disclosed. Congressman Sestak publicly disclosed it, or the administration would still be denying any and all wrongdoing. In the case of Colorado State Senator Romanoff, very clearly, if not for the emails, we would still have complete denial. So, Mr. Chairman, the time has come. So many months have passed since the first announcement in February. So many questions have been asked and none answered, not even by that 1.5 page, we did nothing wrong, or others saying it's business as usual, you didn't expect us to change everything. Mr. Chairman, I would ask that you favorably move this resolution and yield back the balance of my time.
Gentleman's time has expired. Are there other amendments?
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, it doesn't take a lawyer or a judge to recognize that the administration's discussions about job offers with Representatives Sestak and Andrew Romanoff in an attempt to influence Senate Democratic primaries go against the spirit of federal laws designed to prohibit political officials from wrongfully influencing the election process. The Hatch Act prohibits federal employees from engaging in certain political activity. The Hatch Act was enacted to ensure that individuals entrusted with discharging a federal duty on behalf of the executive branch maintain a bright line separation between their jobs and political activities. Similarly, several provisions in Title 18, the Federal Criminal Code, clearly prohibit offering, giving, and taking anything of value in exchange for any political activity. In fact, it is some of these very same statutes that are currently at issue in the trial of President Obama's home state's former governor, Rod Blagojevich. Mr. Chairman, I do not know whether administration officials violated any federal law when they offered jobs to Congressman Sestak and Speaker Romanoff, but it is obvious that in doing so, the administration may have engaged in the type of behavior these statutes were designed to prohibit. I suspect the administration knows this. After all, what was the need for President Clinton to deliver the message to Congressman Sestak? Was it to ensure the administration would avoid any potential liability under the Hatch Act or Title 18? Ultimately, we all work for the American people. The salaries of federal employees, including those who work for the Obama administration, are paid by American taxpayers. We must remember that federal employees are paid to provide necessary government services to the American people who pay their salaries. Taxpayer dollars should never be used by politicians to further entrench their own partisan political interest. This resolution of inquiry will hopefully yield documents that reveal the truth about whether the administration violated federal law. That is why I strongly support this resolution of inquiry. Mr. Chairman, I yield back the balance of my time.
Gentleman's time has expired. Are there other amendments? Gentleman from Texas, Mr. Gomet. Recognized for 5 minutes for the purpose of striking the last word.
All right, thank you for the purpose of striking the last word. I do think this resolution is important. We have seen from this Justice Department over the last year and a half the way they handled the Black Panther voter situation, where you clearly, according to an African-American gentleman that was one of the original fighters for the civil rights movement in the 60s, give an affidavit, obviously under oath, saying it was the worst case of voter intimidation he had ever seen, more so than the 60s. And then, even though all the career people said they wanted to go forward, it was a lockdown case, this Justice Department runs in and drops everything but one of the defendants. They were on video. They had testimony, and they dropped it. So clearly this was more about partisan politics than it was about doing justice. We know that this weekend I saw a newspaper article that said that the 5 people involved in the 9/11 plotting, beginning with Khalid Sheikh Mohammed, had decided to plead guilty They were going to waive all of their pleading rights. They were going to give up all future motions. They were just going to come in, waive everything, plead guilty. Unfortunately, that article was dated December 9th, 2008, and a month later, this so-called Department of Justice runs in and said, we're not going to let them plead guilty. We're going to move them to New York and make a circus out of this thing. That wasn't about justice. Justice was about to be done for the over 3,000 victims of 9/11. And so now the report this weekend is the decision may be put off until after the November elections. Gee, could that be about politics? It ought to be about justice. And then we find out that something we've been trying to get to the bottom of for quite some time, these offshore leases that were executed in 1998, 1999 under the Clinton administration, in which the price adjustment language, we were told in Natural Resources, was actually pulled out intentionally. The guy that prepares them said, hey, you're leaving out this language. He said, leave it out and leave out the addenda. That cost the federal treasury hundreds of millions, and now I'm told it's cost us billions of dollars that went to companies like British Petroleum. And one of the people we were told that was not interviewed was a person named Sylvia Baca, because she would left the government and was no longer in the government service, so the IG didn't investigate or question her. And now, guess what? She's back working for the Interior Department and works for the Mining Management, Minerals Management Service. And nobody, as I found out last week, has bothered to investigate that. It's cost us billions of dollars, and they intentionally pulled this language out and now back working for the government, and we're not doing anything on investigating that. And then we got the SESTAC situation. Never mind that he went to the Naval Academy and that there is an honor code there that he is supposed to, not just at the academy, but always state the full truth. Never mind that it's a violation of that honor code not to tell the full truth. But we've got a Justice Department that could investigate. Just give us the facts. Tell us what happened so we can put this behind us, because there is so much else at stake here. But if there's a crime being committed, we need to know what it is. And I would just simply submit that this really isn't justice. The victims of 9/11 have not gotten justice. Maybe we should change the name to from Department of Justice to Department of Partisan Politics Polluting the Process. I yield back.
Mr. Chairman. Mr. Chairman.
Are there other members? Gentlelady from
strike the
Texas?
last word.
Gentlelady recognized, strike the last word, 5 minutes.
Mr. Chairman, I recognize that we're on a particular resolution, and I just hope that my good friend from Texas has gotten everything that has ever bothered him off of his chest, because that's what his previous statement evidenced. If we begin to talk about politicizing the DOJ, there are many examples of that in the previous administration. But what I would like to say is that on the issue at hand, particularly dealing with Admiral Sestak, former Congressman Sestak, if they will look at the materials submitted to this committee and various letters that have been written, particularly by their own colleague, the ranking member on the Government Reform Committee, these have been asked and answered. And all of this today is, again, a gripe session. The Department of Justice is not politicized. The Attorney General is not politicized. I've not seen him go in the dark of night and try to secure a signature of a sick and disabled person, nor has his staff sought to secure his signature on documents that would violate the Constitution while he was disabled. So we can begin to talk about what is politicized or not, but to the motion at hand, I would say to my colleagues that all that you have asked has already been given. This is not a motion that is to clarify. I believe it is simply to allow a song and verse gripe session. For that reason, I think that we should oppose this amendment and begin to move forward on legislation that will improve the conditions of Americans.
Will the gentlelady yield? Will the gentlelady yield?
I'll yield to the gentleman.
I don't know if this surprised you or not, but I completely agree with you how entirely inappropriate that was to go into ICU and try to get a signature. I agree. Any kind of politics is completely inappropriate. I agree with the gentlelady on that.
Thank you. Reclaiming my time, and I thank the gentleman for his courtesies and honesty on some of my comments, and I'd ask that we could work together and secure any material that we would need from the Department of Justice without this form of a resolution. I would yield back and ask my colleagues to oppose this resolution. Thank you.
Mr. Chairman. Does the gentlelady yield back?
Yielding back. Thank you.
Gentlelady's time has expired. Are there other amendments, Chairman? Gentleman seeks to strike the last word.
Move strike the last word, Mr. Chairman.
Recognized for 5 minutes.
I thank the Chairman. Mr. Chairman, immediately after Congressman Sestak disclosed that on February 18th, the administration had approached him with a job offer to clear the presidential Democratic Senate primary for Senator Arlen Specter, Americans began demanding more information. They demanded it in February, March, April, and May, and as well as the present month of June. Mr. Chairman and colleagues, on Capitol Hill has observed much wrongdoing on the part of Democratic administrations and Republican administrations. Errors in judgment, even a commission of crime from time to time. And in those cases, it seems to me if the alleged wrongdoers had simply come forward and said, fellow Americans, we blew it. I committed a crime, or I made an error in judgment. Forgive me, I'll try to do better. Americans, Mr. Chairman, generally are tolerant. Americans generally are a forgiving people, and I think this issue, this matter at hand now, needs for that sort of transparent foreclosure to come forward. Almost 4 months after Congressman Sestak's announcement, when the administration can no longer sweep its questionable conduct under the rug, it released a one-page memorandum on the subject. Unfortunately, that memo raised more questions than it answered. For example, the White House memo acknowledges that the Obama administration used former President Bill Clinton to discuss possible federal appointments with Congressman Sestak. The $64,000 question, Mr. Chairman and colleagues, is why? Why couldn't the Chief of Staff or even President Obama make this offer directly? Additionally, the White House memo confirmed that Congressman Sestak declined an offer to serve as an executive branch advisor while remaining a congressman. On May 28th, Mr. Sestak said he believed he was being offered a position on the President's Intelligence Advisory Board. There's only one small problem with the White House story. According to the White House own website, federal employees, not unlike Representative Sestak, are ineligible to serve on the President's Intelligence Advisory Board. Simply stated, the administration version of the events is implausible. Finally, the White House memo states that efforts, and I repeat, efforts in the plural, were made to determine whether Congressman Sestak was interested in a quid pro quo. Yet the memo describes only one conversation that Sestak had with the former President Clinton. What were the other efforts? Did any of these efforts violate federal criminal law or applicable ethical standards? President Obama promised the American people that the most transparent administration in history. Yet this administration's disclosure on the Sestak possible scandal is woefully inadequate. While circling the wagons may be good legal advice, it is oftentimes not good political advice. The public rightfully holds elected officials to a higher standard. To ignore this or somehow to argue that questions about this matter are without merit is an affront to the awesome responsibilities that we as elected officials hold in public office. The administration needs to come clean on this matter, clear the air. If laws were in fact violated, those matters can be addressed, but the bigger issue here is whether the administration is willing to hold itself to a higher standard. Ignoring this matter, this possible scandal, will only fan the fires. I encourage my colleagues to vote for the resolution, and I thank the chairman for having called this markup, and I yield back. But first, Mr. Chairman, I'd like to gain unanimous consent to have Congressman Shavitz's statement made a part of the record, and with that, I yield back.
Is there any objection? No objections, so ordered. A reporting quorum being present. Without objection, the question is called. The question is on reporting the resolution adversely to the House. Those in favor of reporting adversely, say aye.
Aye.
Those opposed, say no. The ayes have it, and the resolution is reported adversely.
Mr. Chairman.
Gentlelady from Texas.
Mr. Chairman, I wanted
just a minute. Members will have 5 days to submit views. Gentlelady from Texas.
Mr. Chairman, I wanted to report for the record that I was unavoidably detained in a meeting discussing the jobs bill that has been stalled in the Senate that has been passed by the House. For that reason, I missed the final vote on H.R. 5503, Securing Protections for the Injured from Limitations on Liability Act. If I had been present, I would have voted aye and would like that to be placed appropriately in the record.
Mr. Chairman, may I ask unanimous consent to speak out of order?
I'm in the middle of...
apparently...
I'm sorry. I thought you had finished. I'm sorry.
No, and I asked unanimous consent for it to be placed appropriately in the record.
Without objection.
All right, excuse me. And the motion to authorize issuance of the subpoenas to BP America for documents regarding its claims process relating to the Gulf oil spill. If I had been present, I would have voted aye. Ask unanimous consent for it to be placed in the record.
Without objection.
And H.R. 5566, Prohibiting Interstate Commerce and Crush Videos Act of 2010. If I'd been present, I would have voted aye. Asked for it to be placed in the record. Ask unanimous consent.
Without objection. And I'd notify some of the members not to leave, Ms. Bowler, if possible.
And I thank the chair because of my being detained. Thank you. Yield back.
Mr. Chairman, I'll say it was my fault, but I don't believe the chairman heard me ask for a recorded vote, and I regret that I didn't make that clearer, but I do hope we will have a recorded vote.
We have members who've left. I don't know if we can get them back. If they'll hold the vote open.
Okay, we can hold the vote. We can hold the vote open.
Okay,
That's fine.
well, that's fine.
Without objection, the clerk will call the roll on the resolution 1455. Motion to report adversely.
Mr. Conyers? Mr. Berman? Mr. Boucher? Mr. Nadler? Mr. Scott? Mr. Scott votes aye. Mr. Watt? Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Ms. Wooters? Mr. Delahunt? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Johnson votes aye. Mr. Pierre-Louisi? Mr. Pierre-Louisi votes aye. Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Ms. Chu votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Baldwin? Ms. Baldwin votes aye. Mr. Gonzalez? Mr. Gonzalez votes aye. Mr. Weiner? Mr. Schiff? Mr. Schiff votes aye. Ms. Sanchez? Ms. Sanchez votes aye. Mr. Maffei? Mr. Polis? Mr. Smith? Mr. Smith votes no. Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Coble votes no. Mr. Gallagly? No. Mr. Gallagly votes no. Mr. Lundgren? Mr. Issa?
No.
Mr. Issa votes no. Mr. Forbes? Mr. King? No. Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? No. Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Rooney? No. Mr. Rooney votes no. Mr. Harper? Mr. Harper votes no. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gomert? Mr. Gomert votes no. Mr. Conyers? Mr. Conyers votes aye. Mr. Forbes? Mr. Forbes votes no. Mr. Berman? Aye. Mr. Berman votes aye.
Other members that want to have their votes recorded? not, the clerk will report.
Mr. Chairman, 15 members voted aye, 12 members voted nay.
15 voted aye, 12 voted nay. The ayes have it, and the resolution is ordered reported adversely. Members will have 2 days to submit additional views. Is there further business to come before the committee? Apparently not, so the committee will stand adjourned.